I love Emmental cheese. I have it quite a lot when I stay in France, except I have the French version. Emmental cheese originally is thought to have been in the river valley near Bern, the Emmer River Valley. Tal is an old Swiss word for valley. And the Swiss position is that because this cheese has very particular characteristics and evolved in that specific region of Switzerland, that they should be able to invoke some international law which protects geographical indications. And they should be able to be the only ones who call their cheese Emmental cheese. Other countries like Germany, Austria, and France also have their own version of Emmental, and they've been marketing this, selling it to consumers for years and years. However, there's a series of international legal treaties that most countries in the world have signed, which would seem to give Switzerland a very strong position to claim Emmental cheese as only their cheese, and thus to force the Austrians, Germans, French, and anyone else hoping to have an Emmental cheese not to call it Emmental anymore, but to choose a different name.
Interesting. They couldn't call it, say, German Emmental or from Vienna Emmental, something like that?
Yeah, it's an interesting question because another cheese battle happened between Denmark and Greece about a decade ago. Denmark apparently makes the best feta cheese, but Greece applied to get the geographical indication so that only Greek feta could be called feta. The Danes were up in arms about this, so were consumers, because consumers really liked the Danish feta. But in the end, the Greeks won, and you can only buy feta cheese from Greece. And what the Danes had to do is rename their cheese and rebrand it. And I believe it's called something like Danish blue cheese. Gradually, I think consumers realized that it was the same old cheese, different name, but it's no longer called feta, so it can be a little confusing if you're not a feta aficionado and you're just looking quickly for some feta to put on a salad.
Yeah, and cases often center or claim ownership on local communities versus multinational corporations as well.
Yes. So, well, one of the issues with respect to these legal rights is that they're often claimed by richer countries, countries that are more developed, very rarely by countries that have lower incomes. There was a report back in 2023 by the World Intellectual Property Organization that said that only about 10% of all of these geographical indications are claimed by less developed countries. So 90% are claimed by wealthy countries. And generally, as you just suggested, they're generally exploited by the companies that make the cheese or the wine or whatever the food substance is that's protected by a geographical indication.
Yeah, for example, South African farmers won EU protection back in 2021 over rooibos tea. Local farmers and artisans, protection means higher income, market value, and cultural recognition as well.
Yeah, that's absolutely right. And, the South Africans were fortunate to win. And there's a variety of other groups in South America, India, and I believe in Thailand and Indonesia that are trying to get their particular foods protected by geographical indications so that folks just across the border in a different country, or more likely in places like Europe or the United States, where immigrants from those countries go and bring their food specialties with them, can't call them by the local name. So the local name would be the only name, and any consumer buying that particular food substance would be confident that it came from that particular region, for example, of Indonesia.
And here's, I think, a pretty fascinating question, because backlash after Disney filed copyright for marketing purposes for the phrase Hakuna Matata. We all know that came from the movie, but really nothing much came from the East African outrage over a common Swahili phrase. So how does this case, do you believe, highlight the different approaches of Europe and the U.S. when it comes to geographical indication, and the U.S. favoring trademarks, which could lead to trade frictions and even uneven outcomes?
Well, the Hakuna Matata case, that was a very interesting one. It's unlikely that Disney will ever have strong protection for that phrase, even if it were to get a trademark or to try and copyright it successfully, because it's so short. It's such a short phrase, and it's a phrase that is used by people in the local population. So I don't think that would ever be a very powerful or strong right for Disney. But even so, it was the attempt to protect that that I think outraged people. And I do think that these international treaties, although they're meant to benefit everyone, in practice, they really benefit those who can afford phalanxes of lawyers who can file the right paperwork, file litigations in the correct courts, and then see the cases to the end, which sometimes can cost millions of dollars. There's a lot of countries and a lot of local regions in lesser developed countries that just can't afford any of that. And so they're left out in the cold.
Yeah, and I think in the court of public opinion, it's pretty clear that sometimes those corporations really come out as big losers. Andrew W. Torrance, thank you so much for your insight. We really appreciate it.
Thank you very much. It was an honor being on.